on air, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. School is now open. Please be seated.
Good morning and welcome everyone to today's sitting of the Appeals Court. Was that me? Oh, I'm sorry, I thought I heard an odd sound coming from the microphone. I apologize. Was that you? Oh, I did hear an odd noise. The panel today consists of the three of us. To my right is Justice Kenneth Desmond. To my left is Justice Robert Toone. My name is Ariane Vuono. We only have 5 cases on for today. I can assure everybody that we've read everything that you have submitted to us. 15 minutes is not a long time, so you should get right to your most salient points as soon as you can. And also, some of the cases are only involve a couple of issues, and you need not use all of your time if you don't think that you need it. With that said, I only remind everybody in the court that there is no rebuttal in the Appeals Court in Massachusetts. Okay. First case is Commonwealth versus Shaheed Abdullah, 2024-1031. Good morning.
Good morning. May it please the court, James McKenna for Mr. Abdullah. I would like to get to our stronger of our 2 arguments as to estoppel right off the bat. That is that the court, this court, never decided whether the combination of the resentencing understanding plus the stays of execution constituted a undisclosed inducement sufficient to warrant a new trial. That was not what was decided 5 years ago.
Which piece of that is the newly discovered piece?
The part that was not decided concerns...
I'm saying which piece? We're on here for a motion for new trial, right?
Yes, Your Honor.
Okay, and is there some newly discovered evidence as a result of the remand?
Yes, Your Honor.
Okay, what is it?
The key there is the evidence we got establishes that the testimony of the witness, the key witness, was after, testimony in grand jury of the key witness was after the execution, the agreement with the Commonwealth. They typed up an agreement with the witness.
So hold on. So are you saying that the agreement is the newly discovered evidence?
Yes, Your Honor. The timing...
There is no agreement, right?
The timing of an understanding with the witness was newly discovered. Actually, that goes to our second argument.
The timing of what?
The timing of the agreement with Mr. Jones was...
There was no agreement. What is the agreement?
What was typed in the document that was typed before he testified in the grand jury spoke prospectively about what he was going to say when he got to grand jury.
But that document, as I understand it, was never communicated to your client, was never communicated to either of the defense attorneys, Hayes or Jensen. We have affidavits from the Commonwealth that says that we're never communicated at all. And so unlike maybe Hill, there was no loose agreement. There was no agreement.
There was something typed up by the Commonwealth specifying the details of what...
I get it. I saw that it was discovered in the computer that hadn't been printed out and that had never been communicated to anybody.
Yes, Your Honor.
Okay.
But it was typed. They spoke about how when Jones got to grand jury, he would testify on their behalf. Okay. And this court relied upon that. If I could read what's on page 412, please, Your Honor, please.
Go ahead. Sure.
On 412 of the record appendix from this court, but what this court said 5 years ago, 2020. Okay. When pressed during cross-examination, Jones expressly disavowed defense counsel's suggestion that he only testified before the grand jury to garner favor from the Commonwealth in Jones' own criminal cases.
He did.
That was the understanding of Judge Miller below 5 years ago, Your Honor, and this court, that Jones testified out of what he described as frustration.
Right. He said he was upset because in the drug dealing game that he takes a part of, if you get robbed and you turn over the drugs, you're not supposed to get shot.
Exactly.
So he's mad because he got shot after turning over his drugs. But what's the agreement?
The agreement was, there's an understanding at least with the Commonwealth.
I don't see that. What's the evidence of the agreement? I thought both defense attorneys said we didn't have part and parcel of any agreements. We don't have any agreements. I thought that's what Jensen and Hayes both said.
Exactly. Yes, they had nothing.
All right. And so we have an unsigned agreement.
Sounds
like nothing because it wasn't communicated to the defense attorneys.
In terms of its force, Your Honor could not be more right. In terms of what we can show that the agreement was, all we can show from what we got following the remand was that the government typed up an agreement before Jones's grand jury testimony. That's all we can show.
Right.
And
So that amounts to what?
but that means that Jones, when he's testifying about how he testifies only because of his frustration, no, there was something typed up by the government beforehand. It predicted his grand jury testimony. It predicted the states of his sentences.
Is there any evidence that he knew about that he had any knowledge of this unsigned typed agreement that was in the computer?
It only goes to what was...
That question calls for a yes or no. Is there any evidence that he knew about it?
That Jones knew about it? No. Well,
Well, the judge did find that had he been asked, he would have to answer no, that he did not know about it. The judge made that.
well, then there's no evidence that he knew about it directly, but the fact that everything in the agreement came true would indicate that there was some communication with the defense.
But that's contrary to what the evidence is. I mean, I understand you're saying it would seem reasonable to believe that it was communicated to the defense, but the defense attorney say it wasn't. The defendant said it wasn't. The Commonwealth said it wasn't.
Yeah. And
That's what we're stuck with.
that's why I hope to start with my other argument first, what I call the stronger argument.
Yeah.
That this
Let me
court...
ask you this question.
Yes, right.
What's our standard of review?
It's abuse of discretion or other error of law.
Okay.
And in terms of that, our stronger argument goes to what this court found 5 years ago, that there was insufficient to say that the stays of sentences warranted a new trial. Failure to disclose the stay of sentences warranted a new trial. That's what this court said, standing alone, and that's this court's term on page 411 and addendum page 84. Standing alone, that's not enough. And then this court sent back to Superior Court the question about resentencing.
And why was it, what is your understanding of why this case was remanded at that point?
Because there were indications that there was an agreement, understanding with the government.
To see if there was any newly discovered evidence or an agreement that had not been disclosed, right? That was why it was remanded.
As to
And to
resentencing.
Justice Desmond's point, there was no agreement that then was discovered thereafter.
In terms of newly discovered evidence, yes, Your Honor. In terms of direct estoppel, this court did not decide the combination was insufficient to show that
Combination with what? What's the combination with? We have the stays. We didn't decide that because we want to see if there was anything more. If nothing more comes, where's the combination?
The combination of the agreement for resentencing and for the stays of sentence. That's the combination.
So it feels like we're kind of going around and around because I'm not sure that the agreement is anything new. Because the agreement is really no agreement.
Well, there was the March 2009 discussion with Judge Laureate, in which the Commonwealth and Defense Counsel said, we have to go back to the sentencing judge on this. 6 days later, the Defense Counsel files a pleading in Roxbury District Court saying that sentences are going to be altered.
Is that newly discovered?
It's not newly discovered, but it's not something this court decided.
Whatever, it's not newly discovered, right?
It's not newly, right, you're right, Your Honor.
It went back for the very limited purpose. I mean, Judge Miller decided one of the motions, right? And so Judge Ullman reviewed it and sent it back on the issue. Actually, I think it was Judge Lemire's panel sent it back on the issue of the newly discovered evidence with respect to the agreement, right?
Right, right.
And then at the end of the day, we come up with no agreement. Is that fair to say?
No written agreement.
No oral agreement, no loose understanding. The defense attorneys said, we don't have any agreement.
We have no written agreement.
We have no loose agreement. They didn't say, well, we had a kind of a loose understanding. They didn't say that, did they?
They didn't. We didn't have an evidentiary hearing. We didn't have any evidence come in from them at all.
Did they submit affidavits?
No.
The defense attorneys didn't, only the Commonwealth.
Only the Commonwealth, yes, Your Honor. So in terms...
We have a question over here.
Is your argument that the existence of this unsigned agreement and the evidence that came out about the internal memos where the prosecutor believed that it had to enter into a cooperation agreement to make this work, that's enough to sort of suggest there was some kind of at least informal understanding as to where there's, even if there wasn't a finalized agreement, but there had to be some kind of understanding before leading up to Jones's testimony. Or is that kind of your position, that this is indicative of some kind of informal understanding?
Yes, Your Honor. With respect to argument 2, yes. Argument 2 is about newly discovered evidence. Argument 1, the primary one, the strong one, concerns what this court decided. Yes, assuming there's no additional evidence, Your Honor, you have a question?
No, please go ahead.
Assuming there's no additional evidence, direct estoppel would not apply given the lack of decision by this court as to the combination. This court said, effectively, we're not going to decide whether the combination warrants a new trial. We're going to decide that standing alone, the stays don't, but we're going to send back the question of resentencing. And we got nothing else.
All right, can we decide that question now?
I'm sorry.
Is your position that we can decide that question now, assuming that you're correct, because of course we're listening to your argument. Is that a question that you think that can be decided now, at this point, at this posture?
It can.
Okay.
Except with respect to the estoppel part. In terms of estoppel, it doesn't apply now. The question about estoppel is distinct from that. Did this court decide that before? No, it just didn't. It didn't reach the question as what the combination meant.
Okay.
It didn't get there. It said we're going to remand that part, and we're going to say this part's not enough. And yes, there was no additional discovery in terms of the resentencing, nothing more found. But in terms of direct estoppel, there has to be a prior decision, and there isn't. This court didn't get there.
Okay, we see your point on that.
And unless the court has any questions.
I'll check. None here.
No, thank you.
None here. Thank you very much for your argument.
Thank you very much. Thank you.
Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth. Your Honors, there's a very simple question here. It's whether Judge Ullman abused his discretion or committed some other error of law in denying the second motion for new trial. He did not. As I heard opposing counsel's argument this morning, it sounds like it's all predicated upon there being a clearly erroneous factual finding in Judge Ullman's written decision. And it seems like the finding that he's challenging, you'd find it on Commonwealth's Appendix, page 94, was there is no evidence that the unsigned draft agreement was ever signed, communicated to Jones, or consummated in any other way. That's the factual finding.
Consummation, yeah, that seems really clear. Is it your position that the prosecutor and counsel for Mr. Jones never discussed a cooperation agreement?
That is correct, Your Honor. And that is what...
There was no discussion, no sort of let's think about this, no, because that's something significantly different from the existence of a signed cooperation agreement, right?
Sure, Your Honor. So if Judge Ullman had simply used the word executed, then I would understand your point. But what his factual finding was, the draft agreement was never signed, communicated to Jones, or consummated in any other way.
Well, the agreement not being communicated, but were there discussions, where they're sort of like, this is the deal we're thinking about, this, you do this, you get this. There was nothing like that, no discussions?
There's, as Judge Ullman said, there's no evidence to support that at all. There was no evidentiary hearing here, but Judge Ullman also afforded the defendant 4 separate opportunities to produce some sort of evidence to meet his burden to justify an evidentiary hearing. 2 were procedural orders for written submissions, and 2 were show cause hearings. No evidence was proffered. Other than actually, opposing counsel indicated after his conversations with the 2 defense attorneys, 2 trial defense attorneys, they had no agreement in their files and no knowledge or understanding of any agreement having existed either.
And
so,
I'm sorry, go ahead, I'll finish your answer.
So the point here is that there is nothing in the record that on which you could say Judge Ullman's factual findings were clearly erroneous. So that leaves, there was a draft document that was in the electronic file.
My question is going to, obviously, no issue with respect to whether there is a finalized agreement. Was there something else that was not covered by Judge Ullman's findings that could have induced or been potentially induced Mr. Jones to testify?
Well, no, Your Honor. And in order to, the defendant seems to suggest that there, or hypothesize that there was, but in order to have that information, he would have needed to produce something to meet the necessary burden to justify an evidentiary hearing to then give you this hypothetical information. He failed to meet that burden.
What could he produce to establish that?
An affidavit from one of the defense attorneys that said there was some discussions about it. an affidavit from his client saying there were discussions about it
One
that
of the
he was aware
attorneys
of.
from Mr. Jones, you're saying, that's the evidence that could have
Correct,
established. Right.
correct, Your Honor. And he produced nothing. So he produced nothing to justify an evidentiary hearing on the subject. Judge Ullman properly denied this motion without an evidentiary hearing because the record before him was exactly the same as the record before Judge Miller on the first motion for new trial. This court remanded the case for further discovery about the possibility of an agreement, and there was no evidence to then support that possibility of an agreement. So Judge Ullman found himself in exactly the same position that his predecessor had been on the first motion.
So when he spoke to the two defense attorneys, one defense attorney said, no discussion, no agreement. I think that was Attorney Jensen. And the other attorney said, client privilege?
Yeah.
That is my understanding, Your Honor.
Attorney Hayes.
But it was I'm sorry.
But even following those discussions, they didn't submit any affidavits from those attorneys, right?
That is correct, Your Honor. And also, it was a global change of plea dealing with both cases. So if there had been some sort of agreement about it, it would have existed in both of the two cases with the two defense attorneys, and the one expressly said there was no such agreement.
And did he end up getting the same sentence below? Or was the sentences changed? I thought Judge Ullman said something like at the end of the day, he ended up getting the sentence that he initially had anyhow, even after they continued it.
Your Honor, here's what I recall is that the terms of the draft agreement that were never communicated to the defendant were that the Commonwealth would recommend 2.5 years in the House to resolve both of the cases.
And he got 2.5 to 3.5?
But what actually that was the terms of the draft, the unsigned draft. What the Commonwealth actually recommended at the sentencing hearing was 2.5 to 3.5 in state prison. So the recommendation that they made was not even the same as the terms of the uncommunicated draft agreement, is my understanding.
And what did he get? Did he get 2.5 to 3.5?
I'm sorry, Your Honor, I don't recall what the actual sentence was. To me, the point just being, if you're trying to imply there actually was a draft agreement, what the Commonwealth recommended was not in accordance with that proposed draft agreement that was never communicated. That being the point, that's another inference that that agreement was never actually entered into or consummated in some other manner other than written.
The judge found that the unsigned draft agreement was probably drafted before Jones testified in the grand jury based on its content and based on ADA Bradley's memo. Do you agree with that?
It's a factual finding that the judge made, and I don't have a basis on which to say it's a clearly erroneous
What would be the
finding.
scenario where they would kind of draw up this cooperation agreement but not really even engage in discussions with Mr.
So as was outlined basically in the prosecution memo was that the prosecutor at the time's belief was that he was going to need a cooperation agreement to secure the cooperation of Jones, who was actually the victim in the case. And it turned then, to be prepared, he put together a cooperation agreement in case he needed it, as he indicated in his affidavit. He did not need it. The victim in the case was willing to testify, basically as he described it, because he felt he was wronged in the game he was in. The defendant hadn't adhered to sort of the terms of the game. So the prosecutor here was trying to be prepared in case the document was needed. It ultimately wasn't needed, and that's why it was only ever found in his electronic file.
Do I have this wrong? But as I recall from reviewing the affidavits from Mr. Wakefield and Mr. Bradley, they didn't actually say there weren't any discussions.
Yeah.
They said, well, there wasn't a finalized agreement, right? If there hadn't been any discussions, why wouldn't they just have said in their affidavit there were no discussions?
Well, Your Honor, I didn't participate in the drafting of the affidavits by either of them, so I couldn't answer to what was inside their head when they drafted those two affidavits. But what I can say is that to justify an evidentiary hearing, there is a burden. There has to be a substantial issue and a significant factual showing. Here, the defendant failed to make a significant factual showing to justify an evidentiary hearing where they could have, I don't know, put people on the witness stand and tried to
Let me ask you about that for a second, because of course he has a burden, and you understand that, and the judge also made that observation appropriately. But, you know, based on your experience, you've been around for a long time, do you think it's just a little bit odd that a prosecutor would draw up a draft cooperation agreement and there'd be no discussion of it with anybody?
No, I do not, Your Honor. I think it's an example of a prosecutor trying to be prepared for what he believed the way the case was going to go. So he drafted a cooperation agreement to be ready for it, and as he noted in his affidavit, he could not have executed a cooperation agreement without the approval of his supervisors. Had there been discussions about entering into some sort of agreement, then he would have gone back to his supervisors in the office to make sure they were okay with it, to give them his draft cooperation agreement for their approval, at which time he would have gone back and had it executed. That's the process of how this works. This prosecutor was in the younger years of his Superior Court experience and was trying to be prepared for what he believed was likely the path this case was going to take. The case didn't take this path because the victim was willing to cooperate without a cooperation agreement.
Well, given the situation, what if, for example, which often happens, the defense counsel in this case, they don't really want to file an affidavit, they don't really want to say too much more. And you know that happens all the time as well, right? And there is, what we have here is this, as you have described it, a prosecutor who is ultra prepared, maybe doing extra work that doesn't need to be done, is the way you've described it, right? Just waiting, getting ready for some potential. That's not a basis, as far as you're concerned, for thinking that maybe that we should find out a little bit more about what was going on. I mean, the fact that there was no discussion whatsoever, and of course, as Justice Toone has pointed out, no one says there was no discussion. They just say there was no signed agreement, and there was no communication of the agreement, and nothing was consummated. No one's actually saying that there was never a discussion, unless I missed it.
You did not miss it, Your Honor, but
Okay.
that is, I'm going to point you back to what is the standard to justify an evidentiary hearing, and it is the defendant's burden to meet that standard.
Well, I'm well aware of that.
So here he produced nothing to justify an evidentiary hearing where the things that you're discussing right now or speculating about could have potentially been explored. He doesn't automatically get it. He has to justify the evidentiary hearing. Here he produced literally nothing. Nothing. So he doesn't get an evidentiary hearing. The record was exactly the same before Judge Ullman as it was before Judge Miller years before.
Did Attorney Jensen say we had some discussions, but we just never consummated the deal?
Well, the information from Attorney Jensen came from opposing counsel. And my understanding of what opposing counsel relayed that Attorney Jensen had relayed to him was that I have no agreement in my file and there was no agreement between the parties. That's my understanding of what the proffer was. That certainly suggests that that lawyer was willing to sign an affidavit or draft an affidavit to that
Well,
effect.
maybe that's speculation.
Of course it is. But ultimately it doesn't matter because the defendant produced nothing, and it's his burden to justify the evidentiary hearing. It's not an illusory concept. He has to produce something to justify an evidentiary hearing. Here he did not. As a result, Judge Ullman committed no abuse of discretion or other error of law in denying the motion for a new trial without an evidentiary hearing because the record before him was exactly the same record that was before his predecessor that denied the same motion that this court previously affirmed. If there are no further questions,
One moment, and I'll see.
thank you.
Right there. No. Thank you very much. Thank you both for your arguments. They're both very helpful. Next case on our list is Commonwealth versus Ricardo Fields, 2024-1307. Good morning.
Good morning to the presiding justice, and may it please the court. Rule 30 allows the court to act when justice may not have been done, and it's my client's position that in this case justice was not done. The Commonwealth was constitutionally required by the time of Mr. Fields' July 2011 trial to prove beyond a reasonable doubt the absence of a firearms license as a fact that renders an otherwise protected possession punishable. In the court's case in Heller, the U.S. Supreme Court recognized an individual Second Amendment right, and in McDonald, it incorporated that right against the states. Once incorporated, due process principles under, for example, In re Winship, required the Commonwealth to prove that element, and that's what we're here asking the court to do. In this case, it was preserved. Trial counsel filed a motion for required finding, saying that the elements of the crime had not been met. And then to prove his, or to stress his point further, he then asked for a jury instruction,
Well,
which was,
Attorney Bank, what about the elephant in the room here?
okay, which is?
I think you know what it is.
So if you want to talk about Bruin or?
No, I want to talk about the fact that the case is not retroactive. So what do we?
Retroactivity comes from the idea of when a right is deemed or when an issue is deemed change in the law, it's prospective. However, when it affects a fundamental right, it is retroactive. In this case, Guardado 2 set up this standard, but the problem is we have a right that is fundamental. That's what the incorporation doctrine would hold, is that the Second Amendment right would be deemed fundamental, incorporated against the states. And in this case, trial counsel raised the issue as well as he could.
Trial counsel did a fantastic job, outstanding job to flag this issue, but does that make a difference to retroactivity analysis?
Well, it does, because when we're talking about whether the court can look back, one of the main points that courts look at is whether this is affecting a fundamental right.
But can you look at, oh, okay, so you're the exception to the T doctrine, sort of, okay, that's the argument?
That is the argument.
Because
Hasn't that been addressed? Am I missing something?
I mean, issue preservation itself doesn't do it, because Teague versus Lane itself, the fundamental retroactivity case that was incorporated into our jurisprudence, that was a case where the defendant raised these Batson-type issues really well and got to the Supreme Court, and they said, you're not entitled to the benefit of the Batson rule because it doesn't apply retroactively, right? So it seems like that disposes of the argument that just preserving the issue, even if it's really well done, the way the trial defense counsel did here, doesn't get you around the fundamental problem with the retroactivity analysis. And the SJC has already held in Guadardo 1 that its ruling should not be applied retroactively to convictions that became final prior to Bruin. So aren't we stuck with that?
I don't think so, because, as I said, the case law seems pretty clear. I understand what Guardado says, and in my brief, I kind of parse it out. Well, in this case, it is, trial counsel raised and preserved the issue. In my mind, that goes to fundamental principles of fairness, because the second defense counsel raised it. He understood what the incorporation doctrine does in establishing a fundamental right. He understood that, and even though no case had come down, if you understand that principle, then trial counsel is right. And as we look back on the way Second Amendment jurisprudence has proceeded, trial counsel has been shown to be correct.
Right.
We've already established that.
I'm sorry?
Go ahead.
Well, so the case had been, McDonald had already been decided, and McDonald was the incorporation decision.
McDonald decide, did you say?
McDonald had been decided at the
Oh, yeah.
Right, so incorporation had already occurred. The problem was it hadn't been extended in the way the Supreme Court did in Bruin to sort of say it protects the right outside the home, and therefore the entire jurisprudence about having to show licensure as an affirmative element, that came from the Bruin holding.
I disagree with that for just a sec.
Well, go ahead.
Sure. So Bruin really doesn't talk about licensure. I'll take you back to.
No, Bruin doesn't talk about licensure. It talks about the right to have a gun outside the home. It was the extrapolation of that principle that the SJC applied in Guadardo to sort of say,
Right.
now it has to be proven as an affirmative element. Go ahead.
So if you go back to Heller, Heller says that licensing regimes may be permissible. There are still licenses. Bruin just talks about the subjectivity of the issuing of the license to carry, not about licensing generally. So you're still talking about the main principles that come from Heller and McDonald, that it is incorporated, that it is a right. Once you have that fundamental right, it shifts the burden to the government to prove each element of the offense. In this case, not having a license was something that the government was required to prove after McDonald. All Bruin does is say, is talk about, it does talk about the history and the importance of the right, but Bruin is about the subjectivity of the issuer of the license, not the license generally.
So then what do we do about the SJC's decision in Gauss, if I'm pronouncing that correctly? That sort of said Heller and McDonald don't require treating licensure as an affirmative element. That preceded Guadardo 1, right? So I get a lot of the strength of your position, but you're swimming upstream against not one but two SJC decisions here.
I understand that.
So that's what we're dealing with.
But again,
And which we're required to follow.
yes, but you are also required to follow the U.S. Supreme Court. And when incorporation occurs, that triggers some real due process protections for a criminal defendant. And that's what we're asking that be applied. Because without those protections, How can we say justice was done in this case? This is post-McDonald and post-Heller. And if you look at all of the, now I understand that whether an issue is preserved, whether it's unpreserved, gives the defendant different abilities to argue, but when we're talking about a fundamental right that's preserved, we have McDonald and Heller that are very clear. All you can say is that justice was not done, in our opinion, because the government wasn't required to prove this. And
If we were to follow that to its logical conclusion, basically all principles of retroactivity would go out the window.
Oh, no, not at all, because
Why not?
retroactivity goes to where the government is where there's a fundamental right. It's whether there's a brand new rule that's announced or whether the issue goes to a fundamental right, a constitutional right. And in this case, it does, in which case retroactivity is permissible. But even
It could be, but the court has said it's not. So if we were going to avoid that, then basically we're abrogating that principle with respect to this particular case.
abrogating
And-
which principle? The retroactivity of a
Yeah.
constitutional?
Yeah.
Well, again, that's the point, because if
Okay,
the
so that's,
government,
so I understand your point
if the
there.
government can take away a fundamental right, just,
I didn't want to interrupt because I know Justice Desmond had
That's
a
right. Your
question.
position is it's a new rule? Is that your, at that
that
point?
Guardado is, or that Heller is a new rule? Or which one? Guardado or Heller?
Guardado.
No, I think it's just, it's not issuing, it's just kind of one of those changes in protocol. As I argue in my brief, it's Heller and McDonald that really are the fundamental cases that kind of change the landscape. But if you want to ask my opinion of what's going on here, the courts seem to want to parse out the incorporation doctrine. In other words, you can be a little bit incorporated but not fully incorporated, and that's something that I don't think is quite right. You either are incorporated against the states or you are not incorporated. If you are incorporated, all rights against the government vest, and therefore the government must prove the absence of license, which is exactly what trial counsel said and which is what all the cases have said. It does not seem fair that if this case were held today, the government would have to prove it, but just because it took place in 2011, they didn't. Again, it's post-Heller, post-McDonald. Guardado does not do anything fundamentally new with respect to Bruin. They're just kind of building off of those earlier cases of incorporation. Justice Desmond, did you have a question?
I mean, we have the plain language that tells us what is retroactive and what isn't. Are you suggesting that we should just turn a blind
No, I
eye
want you to
that?
use that language. So you're talking about the language in Guardado too?
Yes.
In that
Just
case,
turn a blind eye to it? I mean, how do we navigate that?
gingerly, you thread the eye of the needle, because you're dealing with two Supreme Courts that are issuing their decisions, whereas Guardado 2 says we're going to limit this retroactivity to post-Bruin, or after Bruin, but you have U.S. Supreme Court, and its decisions and jurisprudence on incorporation are pretty clear, going back to the 70s and before. So once Heller recognizes that right, and once Heller incorporates that right, or McDonald incorporates that right, those protections for a criminal defendant have to vest. They can't just vest a little bit, or vest when a case is on point that allows the court to act. Otherwise, it seems fruitless to talk about whether justice was done, and that's the standard. If there are no other questions?
One moment, I'll see. Nothing here. And thank you. No, thank you very much for your argument.
Good morning. May it please the court, ADA Lindsay Conkey with ADA Aaron Knight. As your honors have already pointed out, this court is bound by the decision the SJC made in terms of the retroactivity in Guardado, and because the defendant's conviction was final in 2015, almost 7 years before Bruin was decided, he is not able to benefit from that remedy. Guardado has not carved out any exceptions, and therefore the argument that my brother has made must fail.
It seems like his strongest argument is like the issue preservation.
Right.
Right, that like the prescient defense counsel made this argument based on Heller and McDonald, and ultimately the position advanced turned out to be the right position, at least following Bruin and Guardado one. So do you have any case law in Massachusetts, one way or the other, that talks about the relationship between issue preservation and retroactivity analysis?
I don't have any case law for you. I'd be happy to submit a 16L after the fact, but I will say that, as you actually already mentioned, Guardado did consider McDonald and Heller in their decision, and they considered why it should not be retroactive to the McDonald decision. And for, I think it was 12 years after McDonald was decided, we had Gauss, which said that it was McDonald and Heller only considered inside of the home. So it wasn't until Bruin came down that we had to come up with the new burden for licensure. And so that's why it shouldn't be retroactive to McDonald. And so the SJC got it correct in saying that it would be retroactive to Bruin.
I guess just going back to the fundamental, I mean, if the defendant were to prevail, the ruling would have to be along the lines of, sure, that's the standard retroactivity analysis, but there's a different rule when the defendant raises in a very clear and forceful way this argument that ultimately proves to be the valid argument. And so I guess I'm just trying to understand, does anything in our retroactivity analysis speak to that issue about the relevance of an issue being preserved at trial?
Not that I'm aware of, and that is something the SJC could certainly consider, but as of right now and today in this court, we are bound by what the SJC has already said with Guardado. So I don't believe that my brother's argument can succeed here.
Okay.
There's no further questions.
I'm gonna check
Okay.
with the panel. No questions here? Okay. No questions. I understand that you're a student practitioner. Is this the first time you've appeared in front of the appeals court?
Actually, I graduated in May, so this is my
Oh, so that's no longer the
time
case?
in the court, but I haven't gotten my bar
All right,
results yet.
okay,
so
all right.
I'm
Well,
in-
since
I'm
you're
in
no
the-
longer a student, you're you're an attorney, then we'll just welcome for being here, and thank you both very much. Thank you for your argument, as always, Attorney Benyon. All right, our next criminal case on for this morning is Commonwealth versus Jorge Castillo, 2024-0341. Good morning.
Good morning. May it please the court. William Corman on behalf of the defendant. Trial counsel said it best in this particular case, where there was no way that a jury could look at some 15 to 20 other incidents of sexual assault and not consider propensity evidence. I would suggest to the court, as you're well aware, that in order for this sort of evidence to be admissible, there's a two-part test. The first is that it must be relevant to something other than propensity, and the second, that the prejudicial effect must not outweigh the probative value. And in neither of those prongs are we even well within the guidelines here.
Well, and the third prong would be abuse of discretion. We look at the judge to see whether or not, in this case, it's he abuses discretion in admitting the evidence, correct?
Yes, Your Honor.
Okay.
Yes.
And I interrupted Justice Desmond, I'm sorry.
Was part of the defense that there could have been some confusion because the defendant would play and wrestle with the kids, and, you know, that's as far as it went? So,
What I would suggest is this.
was part of the defense that it could be mistaken because the defendant says, I used to play and wrestle and spin around the kids.
On some of the...
Maybe that's what they're referring to.
I understand where the court's going with that, absolutely.
Is the answer yes or no
Yes.
to that? Okay.
But regardless, when we have situations where there's allegations of, touching in a car, where there's allegations of sexual assault in a kitchen, none of those things fall within the guidelines with which Your Honor is discussing.
With respect to the 15 or 20 other incidents, was there any testimony at all about the nature of those incidents or where they took place? Or
Not that I can
conduct?
recall. It was essentially a blanket statement that there were other incidents that took place. And the problem is, again, defense counsel says there's no temporal scope, there's no facts surrounding them, there's absolutely nothing. I can't defend against, a dozen other incidents that I have.
Let's back up. There was all of the allegations are within one period of time, during the time when the child was being taken care of.
Correct.
And babysat. So there is a temporal parameters, correct?
Yes, what I meant by that is the alleged victim didn't say it happened in January or it happened on.
We know that's not going to happen. I mean, this is a child, so
No,
to your credit, or to the judge's exercising discretion, that has to be considered. A child is not doing that. So what is the evidence and how close was it? So correct. I mean, we have to take that in. But so that's one is you would agree that it happened in the same period of time as the alleged incidents that were alleged in the indictment. Okay, so temporal scope we have, right? Now you're indicating there was 15 or 20 other incidents.
That's the quote.
Okay, from the victim.
During
right?
Yes, that's what they were talking about.
Right, exactly. But there was never any real specificity about those 15 or 20 incidents.
Correct. Correct, because had there been specificity, then defense counsel wouldn't be able to say, how can I defend against this? It's just a statement that's out there. And that's the problem. Had there been specificity, defense counsel could have said, and again, I'm hypothesizing here, it couldn't have happened on January 8th.
Okay.
He was in New York.
You're saying there could be an alibi. There was no alibi defense. They lived together. They babysat every single Monday.
But it could have been. It
wasn't one of those kinds of cases.
But it could have been more than just an alibi, because having specificity surrounding an event doesn't necessarily create an alibi. For example.
Why isn't it better just to say 15 or 20? I remember, not sure. Isn't that better than having specific incidents of conduct?
Better for whom?
The defendant.
So.
Thinking of the prejudice prong.
I mean, I suppose that. I'm going to give the world's greatest legal answer, which is it depends. Because again, the lack of specificity allows defense counsel to sit up there and say, we've heard nothing about the specifics of these incidents. Right. But if there was specificity, it happened in the kitchen in front of the green refrigerator. Again, we're not talking about an alibi, but defense counsel could say the green refrigerator was purchased 2 years ago. It wasn't there 12 years ago. It's not an alibi. It's something else. It's something for defense counsel to point at and say, this is why you can't believe this victim, because she is just simply adding things to this. So now that I'm saying it out loud, I'm actually going to disagree with Your Honor, and I actually think that specificity is much more helpful than these vague notions, that we see it in cases all the time, which is it happened all the time.
Your advocate legs have not deserted you at all. So I see your point there. Okay.
When do you think uncharged conduct is permissible?
When it's permissible, I'm sorry, Your Honor.
Yes,
I think when it fits into one of the narrowly carved exceptions, identity. Oh. There was no question about identity here. State of mind. Again, as defense counsel said in the motion in limine, there's already a zillion charges here. We don't need additional state of mind evidence. It's here, right?
The state of mind, the defendant's state of mind?
Either one's, quite frankly, but yes, the defendant's state of mind. Mistake of fact. There is some temporal issues here.
So do you think it goes to state of mind where defendant's defense is, we were just horse playing, and it was an accident?
I don't believe so.
Accident. I don't know that he said accident, but
I don't believe so, and one of the reasons I don't believe so is because of the specificity of the other issues that are here. So again, we have an alleged victim who's testifying relatively specifically, although her chronology is all messed up, but we have an alleged victim, who's testifying as, this happened here, this happened in the kitchen, this is what's happening then, and then there's this throwaway, practically, and it happened another dozen or 15, 20 times.
So essentially she was saying, it sounds like to me, that, virtually every time we went over there and he babysat us, there was some groping and he was feeling us up.
And that is what I would suggest, as Justice Singh discusses in her dissent in Childs, that's where we have a problem here. That's where sort of the exceptions in the rule bump into each other, and it's problematic. Again, and I would also say that from a factually specific point of view, this wasn't an allegation of there wasn't one charge against Mr. Castillo in this particular case, and then these other statements. There were 9+ charges of sexual assault with relative specificity.
Sure, and the jury found him not guilty on one, right, the younger sister?
Yes, with the younger sister, correct, who isn't testifying that this happened.
So they didn't buy it all, right?
Well, they didn't buy the younger sister's testimony necessarily, as opposed to the older sister's testimony. But I do take issue often with the notion of, because an individual is found not guilty of some offenses, therefore, the Commonwealth is absolved of all their sins. I don't think it works that way. There can be a zillion reasons why a jury chose not to find or to acquit on something.
The point is that the jury didn't get swept away with sympathy or bias or some emotion just to find them, outright guilty on all charges.
I understand Your Honor's point. I don't draw that conclusion when a jury finds a defendant not guilty of 1 or 2 counts when there's a multiple of counts for them to look at. I think we do it all the time. I think that's a dangerous notion, because there can be a million other reasons. And so
when you say we do it all the time, you're pointing to the fact that our case law says that it is a consideration. And you disagree with that observation. I understand.
Yes, because we never know why a jury chose to acquit. I mean, they could have made a particular decision about things that have nothing to do with the grand scheme of argument here. So, again, I refer to, Justice Singh's dissent in Childs, which I really think is an outstanding decision.
Too bad it's a dissent.
I understand. But this case, the Castillo case, I think dovetails perfectly with what she wrote in that dissent, because here we have evidence of sexual assaults. We have clear evidence. The jury convicted Mr. Castillo of them of specific things, and again, it's this other, these blanket statements, and I mean no disrespect to the victim when I say these blanket statements, that's what the problem is, because there is no need for this extra information to come through, and that's a problem, and that's what Justice Singh talks about in the dissent. We are gilding a lily that need not be gilded here, especially when we have multiple charges for which a jury can take a look at, despite the fact that there were some acquittals on some and mistrial on others.
Let's say we agree with you. There was already a case where there was multiple charges. Defense counsel made that quite clear in the motion in limine and in the hearing. But then we have still the prejudice prong that Justice Desmond has brought to your attention. That the jury was obviously not really swept away, and 2, we have to decide how much difference did it really make on the jury's deliberations to know that of the X number of times over a long period of time that these events happened, that the child victim said, and it happened another 15 times too, right? So could you focus in on how prejudicial that was to your client?
Absolutely, because again, I would suggest that it's the definition of prejudice, because defense counsel's able to argue specifically about the things that he knows the 4 walls around, and with the sole exception, as Your Honor correctly pointed out, of the timeline, right? Because the babysitting occurred during a significant period of time. With the sole exception of that, defense counsel knows nothing about what these allegations were. Not only that, not only do we not know what the allegations were in terms of where they happened, we actually don't know what the specific allegations were. So defense counsel is left defending against an amorphous allegation.
Well, once the judge made the ruling that the uncharged conduct would come in,
yes,
there was an opportunity then to ask for a voir dire of the witness and to get some more specifics if at that time you felt that would have been helpful, right? And that's something that does occur.
Sure, but I don't think that fills the prejudice gap here. I think the prejudicial gap where an individual like Mr. Castillo is charged with multiple counts, and there is this statement with absolutely, there's no question in my mind anyway about state of mind, about motive, about intent, about identification, about any of those other things. We simply have this overwhelming amorphous statement out there that, as trial counsel said, is next to impossible to defend against.
Did the judge gave a jury instruction?
Yep, there was a limiting instruction.
As the evidence came in, and then again at the close of all the evidence?
Correct.
Right. You want to talk about the House of Horrors?
I'm sorry.
Would you like to talk about the House of Horrors?
So, you know, I find myself up here often discussing about statements that are made in closing arguments, some objected to, some not. Obviously, this one was not objected to. There are these key phrases that I channel my inner Justice Brown when I talk about how the government should know better than to make these statements. And sometimes it's not just...
We channel him too.
I appreciate that. Not enough, because it's been a long time since a case was flipped based upon a closing argument, but nevertheless. And Justice Brown was swimming upstream every time he brought it up.
You think this was the case for that?
I think that in combination with the prejudicial evidence that came in, this could be it. But again, what we have here, and I say this with all due respect to my brother, what we have here is there are closing arguments that we've all seen where there are statements that have come in that are gray, we have statements that have come in that are murky, but we have some statements in closing arguments where there are catchphrases that the court, this court, and other panels have said over and over again, you really shouldn't say that. And here we are again. And here we are again.
And that sounds very much like Justice Brown. But this, of course, is a different standard of review. And most of the cases in which he held the Commonwealth accountable, and I wasn't sitting on that
Yes,
side of the bench many a times when he held the Commonwealth accountable,
Yes, Your Honor.
there had been an objection.
And I understand that, and I do understand that, but at
So back to Justice Desmond's point, this is a case that is a little less, perhaps, noteworthy in the sense that we have a substantial risk of miscarriage of justice standard of review, one line only.
I agree.
The usual jury instruction, argument is not evidence.
And I agree, and I know that this argument two, if there is if the court writes a decision in this case that's more than a few sentences long, my argument two will be relegated to a footnote, which is simply going to say, this statement was better left unsaid. And I appreciate that. But at some point, the weight of all those, this statement would be better left unsaid, has to tip the scale. Or what stops, and again, I say this with all due respect to the Commonwealth, what stops them from just doing it over and over again?
Did the prosecutor refer to the 15 to 20 times testimony in closing?
I believe so, but I don't know that I can put my finger on it right now with my flashing red light.
Because I don't see it there, but...
Thank you very much.
Nothing else? Nothing else. Thank you very much, sir.
Good morning. May it please the court, Andrew Covington for the Commonwealth. I was also the trial attorney on this matter as well.
Oh, Brett Brown would love that too, I have to say. He would just always say, where's the trial attorney? Now here you are.
I'm here, Your
Okay,
Honor.
all right.
Hey, thank you.
So we're not going to say this again.
So what do you think? Do you think House of Horrors was fair, or do you think that should have been left unsaid?
Absolutely, Your Honor. I do feel that it was fair. Right when the defendant filed his brief in this case, the Phillips case came out from the SJC, which was a homicide case, describing that the prosecutor using the phrase monstrous crime was proper. And that was made in open-end statements, which the Commonwealth is even less restrictive in open-end statements. I made that statement in closing argument. That SJC decision also cited the Alimony case, which was also a homicide case, where in open-end statement the prosecutor described the gruesome, horrific homicide and the string of crimes that this defendant committed on several women as part of a horror story. So stronger language has been upheld by review in courts. I would suggest that the Commonwealth's reference in this case was not even as strong as in those two SJC cases, which again were made in open-end statements.
Let me say this though, because the Commonwealth is held always to a very high standard, right? And so even if we absolutely agree with you, the SJC case came down, same words, we're going to say that it was all right. Doesn't it behoove you and every prosecutor in the Commonwealth to just stay away from things like that? You had a good case. The case was tried fairly. Why skate so close to the boundary?
Your Honor, at this time, the verdict that came out after jury deliberations is a little different than the arguments I was making in closing statement. At the time, the Commonwealth was arguing and asking the jury to find the defendant guilty of two very serious charges of aggravated rape of a child on JS and also sexually assaulting her sister, CS. So there was two victims at the time that the Commonwealth was asking the jury to convict of. Also, the evidence came out that CS's own brother witnessed one of the sexual assaults.
That's what I mean by a strong case. I don't recall very many cases where there's actually a witness to a child sexual assault. Very unusual.
I agree. The jury did acquit the defendant on that particular charge.
I know, but still in all, that you're evaluating the case at the time you're doing the closing argument.
Absolutely. The Commonwealth believes that this argument was proper. I'd also like to point out the powerful first complaint testimony that came out in this case, where the first complaint disclosure involved JS and her sister, CS. They were about 10 or 11 years old. They were in the bathroom. JS was in the bathtub, CS was using the toilet. Don't ever leave me alone with him again. He has been sexually assaulting me. The two young sisters, 10 and 11 years old, made a pact, knowing that they'd get home from school, they'd have to walk over to their uncle's house, where they've been hundreds of times, knowing that they may both be sexually assaulted by their uncle.
But to Judge Vuono's question, I guess the issue is, to what extent, as a prosecutor, you let the facts speak for themselves, as opposed to kind of making these rhetorical flourishes that could be viewed as sort of inflammatory?
I understand, Your Honor. The House of Horrors comment, which is how the Commonwealth views it, is a metaphoric term to describe a scary place or a horrible place, and that's what the Commonwealth's inferring. The Commonwealth does not agree that this argument was improper. It was a horrific place. It was the defendant's house. It was a horrible situation for the two victims to be going to. That's what the Commonwealth was arguing in our closing argument. So the Commonwealth does not believe that that argument was improper. Could the Commonwealth left it out and the jury likely would have convicted the defendant of the charges they did? Perhaps, but the Commonwealth does not believe that that brief statement that I made in a 12-page closing was improper. It certainly does not rise to the level of substantial risk of miscarriage of justice.
Let's talk about the 15 to 20 testimony.
Incidents of uncharged conduct. Yeah.
Absolutely.
Yeah, and when you moved to eliminate, to admit this evidence, you said, well, it may be admissible to show inclination to commit the acts charged in the complaint if sufficiently similar, not too remote in time. And you don't seem to be making that argument now on appeal. You seem to be making a different argument that it pertains to something else. So what is the probative value of that testimony?
And I believe when I filed my motion in limine, I know this isn't part of the brief, but the decision came down that the Commonwealth can no longer ask for a list and a laundry list of all the reasons that 404B list. So, meaning that under the jury instruction, there's common plan or operation or modus operandi. The Commonwealth did not ask the court to list that once the trial started. I believe the Commonwealth corrected course, and we came upon an agreement for the court to list 5 specific reasons how the jury could use this evidence.
Motive, opportunity, state of mind, intent, or relationship between the defendant and the complainant. So which of these was that? Which all of them?
All 5, and all 5 are proper. I think any time.
How does the fact that there were 15 to 20 other incidents show motive?
Motive to sexually assault his 2 nieces. That's what was the Commonwealth's argument at that time, to get them alone, to get specifically JS alone, whether it was in a bedroom or whether it was in his car or in the kitchen, and to do it during the time when she was being babysat. There wasn't allegations that this took place at other family events or things.
Well, that sounds like modus operandi, not like motive to me.
Very close, and I believe there is some overlaps, Your Honor, with all 5 of these. There's some potential overlaps.
How does it show state of mind?
His mental awareness, his state of mind, which also kind of overlaps a bit with intent, but as was brought up on the defendant's argument, was that the defendant in a statement to the detective said that this could have been a misunderstanding, that he would be outside with the kids, spin them around, grab them, and play with them.
I don't see a very clear position for the probative value of this testimony that's distinct from the defendant had propensity to commit the crime charged, right? I mean, that's clearly the effect of this happened 15 to 20 other times. I'm not even going to tell you about those times, right? That's very damaging testimony that shows that the defendant had a propensity to commit this crime charged, right? So how do we, I know that the judge gave a limiting instruction, I just don't quite understand how we kind of disentangle the prejudicial effect of this testimony from the purported, acceptable basis for it coming in.
Yes, sir. And you also have nature of the relationship, Your Honor, which I think is important. And the Commonwealth's motion in limine was not titled motion to admit other bad acts or motion in limine to admit prior bad acts, not something that happened years prior to these charged offenses. They happened during the same time. And the Commonwealth would take issue that there wasn't specificity to these 15 or 20 uncharged conduct. The victim clearly testified that it took place during the same time of the charged conduct. She testified.
I'm sorry, you take issue with the specificity?
No, that there wasn't, the argument that there was no specificity for the defendant to be able to counteract this argument at trial.
You think there was specificity?
Yes.
But we don't know in the other 15 or 20 times where the children were touched. For starters.
JS did say breast and vaginal area. She said that during those 15 to 20 times. It's clear that it was during the same time of 2013 and 2015.
Right, but out of the 15 and 20, we don't know were 5 to the breast, were 10 to the vagina. We don't know anything about it. And she said that in response to a question from the prosecutor.
That's correct, Your Honor. And the defense also had a chance to cross-examine her as well, and she said that as well. Now, he was convicted of touching her on the breast and vaginal area, so the uncharged conduct is the same conduct that he was convicted of. But I would agree, she didn't delineate that it was 7 times breast area, 8 times vaginal area, but she said it was breast and vaginal area.
Are we to take anything from the fact that the jury was hung on the rape charges, but convicted only on the indecent A and Bs?
Absolutely, and I think that goes to both issues. That goes to that the jury was not overly swayed by either issue, whether it's the Commonwealth's closing argument or the evidence of uncharged conduct. They acquitted the defendant on 1 count involving the defendant's sister. Involving the victim's sister, and then they were hung on the most serious charges, aggravated rape of a child. So yes, absolutely. The judge gave immediate, on-the-spot, limited instructions when JS was testifying, and then again in closing. Also, the defendant was convicted of intimidation of a witness, and I want to stress this point because I didn't stress this in my brief enough. The Commonwealth alleged that the defendant intimidated JS after the sexual assault multiple times, almost after every time he sexually assaulted her. Don't tell your parents, even gave her money at one point. The Commonwealth alleged diverse dates in that indictment. It was 1 charge, but it covered a time span of 2013 to 2015. The judge gave the specific unanimity instruction, which also goes back to the uncharged conduct, how the uncharged conduct of the uncharged sexual assaults is relevant for intent, motive, state of mind, opportunity, nature of the relationship involving that particular charge. Because again, we weren't alleging a specific act in intimidation of a witness, but diverse dates. So the Commonwealth believes that that is another reason why the uncharged conduct was appropriately admitted at trial. Also, that the Commonwealth would submit that the jury was entitled to a full picture of the nature of the relationship here. These were not just 4 or 5 isolated incidents. The jury heard evidence that JS and CS went to the defendant's home upwards of 700 or 800 times over the course of a year, every Monday and some Wednesdays as well. Without that evidence coming, which again goes into non-propensity evidence, the jury would be left wondering, did this only happen once? Did this only happen twice? And also, the defendant's argument at trial was that JS was lying, was that she made this up. She had a motive to fabricate, that this was based on a dog bite that took place at the family residence years later, and that's why she came forward so many years later alleging that the defendant sexually assaulted her. So the Commonwealth was fair to rebut that evidence as well, specifically in closing argument. I would also point out that time is not an element in indecent assault and battery, so the fact that the defendant makes an argument that, well, we don't know exactly when it took place, that's not an element, and the defense needs to show prejudice here, needs to show how the defense would be different at trial had the Commonwealth alleged more specificity in the timing of the uncharged conduct. I think the fact that the judge gave limited instructions twice on uncharged conduct and instructions twice on closing statements, that both of these issues work out in favor of the Commonwealth, and the court should affirm the defendant's convictions. In sum,
You think that the 15 to 20, I mean, you agree that the 15 to 20 testimony was prejudicial, right? That's why you offered it.
Yes, but not unfairly prejudicial. And the court did apply the balancing test. The motion in limine was argued well in advance of trial. We argued the motions in limine in October. Judge Carey, the trial judge, carefully considered the balancing test. He referenced that at the motion in limine hearing date. He said he was going to take it under advisement, and then right before trial start, he issued his ruling on the record that this evidence comes in. So prejudicial, yes. That's why the Commonwealth was seeking to admit it for those limited purposes, not for propensity purposes, but for intent, motive, state of mind, nature of the relationship, but not unfairly prejudicial. And any limited instructions would have cured that. And obviously the jury's decision in this case, which was a split verdict, shows that they weren't unfairly prejudiced by this evidence. Pending any questions that the panel may have, in sum, the Commonwealth would submit that the trial judge acted well within his discretion, again, abuse of discretion, on admitted uncharged sexual conduct with the same victim during the same time frame. And the prosecutor's brief comment about the defendant's home being a house of horrors was well-grounded. It was supported in the evidence, but alternatively, it certainly did not create a substantial risk of a miscarriage of justice. The Commonwealth respectfully requests that this court affirm the defendant's convictions. Pending any questions, I will rest on my
One
brief.
moment, I'll check to see. We have no questions here. No, no questions. Thank you both very much. I'd like to say the briefs were excellent in this case. The arguments were very well, helpful, and thank you both for answering all of our questions.
Thank you, Your
Appreciate
Honor.
it. The next case is an impounded case. I remind everybody now. It is 2025-0295, the Department of Children and Families and another versus Mother and another. Excuse me for a minute. Okay. All right. I'm just going to double check on some housekeeping matters, which is with respect to the split time, 7.5 minutes and 7.5 minutes? Okay, fine. All right, so then Attorney Duran? And I think I already mentioned that the case is impounded, and I know that you won't.
Yes, thank
You won't make that error, and I speak mostly for myself because sometimes it does happen, but we'll all be very careful today.
Sure.
Thank you.
Good morning. May it please the court, Colleen Duran presenting on behalf of the appellant mother for oral argument today. The brief and reply brief were prepared by prior counsel Attorney Dennis. Your Honors, this case is all about substance use as the judge clearly stated at the trial court level. And the mistake in this case that's terribly unfair to mother and is an abuse of discretion by this juvenile court is that on September 4th, 2024, the third day of trial for this case, the juvenile judge failed to sign the court order for mother's treatment records and allowed them to come in as additional evidence and allow a continuance for the records to be entered into evidence. I would like to explain to this court the procedural steps that the trial counsel took in an attempt to get these records in. On August 9th, the case goes forward.
Why don't you tell us now, what would the records have shown that was not already presented at the trial?
Yes, Your Honor. Mother did testify at trial, and she did testify that she was in treatment the last 8 months. She was, participating in drug screens, Alcoholics Anonymous, Narcotics Anonymous, also in therapy. So the treatment records would have shown that she was participating, and it was 4 drug screens that she was trying to get in.
Is that disputed? Sorry. Is that disputed?
Is that disputed? Well, the records were not certified.
I understand, but it seems like the Commonwealth agrees that she was doing better and that in the last 8 months she had been, fairly compliant. And so I'm asking, is that
Well,
Was that
yes,
evidence disputed?
it's not that it was disputed, but I think it's so important in these care and protection cases that not only do we have the witness by testimony on the stand, but we also have proof. A lot of the care and protection trial judges want to see those drug screens.
But
So-
here, the judge did find, I mean, there was no question that there was positive gains, commendably so.
Yes.
To your client.
There was positive gains. And Your Honor, the DCF attorney was challenging these records and evidences coming in. So
But the records.
Sorry.
I'm sorry. I defer to my brother.
No, just to make clear, the judge acknowledged in her decision that the mother had consistently improved in methadone maintenance since 2024, but concluded that this evidence of recent improvements had to be considered within the context of earlier and continuing deficits, right?
Yes.
So just assume you're right about there was some kind of procedural error here. What's the prejudice? Because the judge found that she had done better on methadone maintenance since 2024. What's the harm here?
the judge did find she did do better, but if you were to refer back to the findings, I believe it's on page 5, the judge actually made a note that mother's testimony, I believe, was not credited. So therefore, these records were significant. And just to get back to August...
But there were other portions of the testimony that the judge could have been referring to. It would be seemingly inconsistent to have made the finding that Justice Toone has referred to about the positive gains. There were other issues with respect to mother's testimony that might have been, the judge clearly found questionable.
Yes, but I think that what the judge made clear was the central issue in this case was the substance use. So maybe those other issues were all stemming from the substance use. And if I could, just to get back to August 9th, the trial went forward and all parties rested except for mother, and mother's attorney states at that time, I have records, I believe I have additional evidence, I want to be able to talk to my client. The judge agrees and asks for more time. August 20th is a very important hearing date. On that hearing date, mother's trial attorney comes forward.
So that's to say that there was a grant of one continuance?
One continuance, sir, yes.
Or two?
There was actually two. So I'm getting to but you're right, Your Honor. On August 9th, the judge did agree that there should be a continuance to give trial counsel time to get these records in.
A 2-week continuance, right?
To August 20th.
And the counsel had asked for 7 days, and the judge said, I'll give you 2 weeks.
Yes, the judge gave additional time. So on August 20th, mother's counsel does state that he has records. He has treatment records for treatments that he'd like to produce, and he has a letter from the Taunton facility where mother was attending for a methadone clinic. And the trial, and there's a lot of discussion before I talk about the September 4th where the abuse of discretion occurred. There's a lot of discussion on this August 20th.
I'm going to ask you to just pause for 1 second. The delay in getting the documents, was that in part and parcel because they didn't have releases by your client?
And that was discussed on August 20th. So there were releases by the client that was submitted to the department because very important discussions occurred on August 20th. The trial attorney says, I have an offer of proof. I want to be able to put these in. They were marked as identification, the records, and the treatment letter. But on August 20th, the judge makes very important statements. She says that the central issue has been substance abuse, and these records are highly relevant. And the reason she said that, because she was getting pushback from the DCF attorney. The judge further states that the stakes are so high in this case, DCF, you're asking for termination of parental rights, and therefore, I'm going to probably give this attorney the opportunity. And the judge also knew that there was a lot of difficulty. DCF has the burden here, and they didn't get the records in. The judge has dialogue with the DCF attorney. Basically states, so I want to make it clear, during the testimony, your social worker testified you had releases, and the department knew that she was participating, and the agency did not comply with the department. DCF simply replies, as far as I know. And then the judge says again, as a result of that, you didn't file any motions, you didn't take any additional steps. And the judge keeps referring to the Virgil case, and I think the Virgil case is important because records came in that proved unfitness for a parent. So if the judge has in her mind this Virgil case, it should also be very important that any records that show that a parent is doing well should come in. So that was in the judge's mind. And what's also important, child's counsel made several comments as well. She was aligned with the department, but she made several comments that favored mother. Mother's doing better than she ever has in years. This was through her cross-examination as well as her closing. She says, I see her in court. That speaks volumes. That was child counsel's word. So mother was in court. She attended all 3 days of trial. She's immersed in treatment. And when asked about the records, the judge asked her opinion as to the records. She said, well, it's DCF. It's so difficult for them to get records in. They're a big machine. These parents are up against, difficulty, paraphrasing. And then she did say one thing, but I think it's improper, or I'm sorry, I'm paraphrasing there, but that this is the 11th hour for the mother to be getting these in. The judge quickly corrected her and said, no, counsel, this is not the 11th hour. Mother's doing well. DCF knew she was doing well. Mother and trial counsel tried to pursue this. And so the judge agreed to one more continuance for September 4th, but said no further continuances. What happens on September 4th, and this is going back to the DCF attorney, wanted not just these few records, but all the records. So what the trial attorney learns from the treatment facility is that he now needs a court order. So before September 4th.
Could any of that have been determined prior to the trial?
Yes, Your Honor. I guess in hindsight, we can always probably do a little better job for our cases, but a lot of us as court-appointed attorneys might be managing a big caseload or a couple cases that are just so busy. But he kept fighting. He kept fighting for mother. So he came back and before September 4th, he files a motion to get the court order signed, and the judge receives that court order because the clerk's office calls mother's counsel and said, we also want a release with this. So that was a little bit of difficulty that the trial counsel admitted he was away, but he comes on September 4th. He now has the release from mother. And trial judge never said she wasn't going to sign that court order. But he comes, there's a lot of discussion on that date, and on that date, they proceed with closings, and the trial judge does make the decision that we're not going to have any more further continuances.
But counsel says he only gets the release from the mother on the day that she wanted the additional continuance, right? I mean, there's a question of, was counsel being reasonably diligent to get these records? And it doesn't, the whole process seems to start after DCF and the child close their cases, right? And then there's this additional 2-week continuance, and then after the 2 weeks are up, counsel comes in and says, well, I just got the release from the mom, and so therefore, I'm not sure there's a clear record here that diligent efforts were made. Can you speak to that?
Well, I think the trial counsel really worked hard to get this information in, and if mother had 7 or 8 months where she was sober, where she was doing well, attending all these programs, DCF knew this, and they had the burden. So they had those 7 or 8 months. So the abuse of discretion really comes into play here. The judge, what could have been done, this trial was done 3 dates, very quick trial. Three non-consecutive dates within 27 days. And as we know, in these care and protection cases, they can go on months or even a year. What was the harm? There was no harm to the child in signing this court order or the judge using the vast resources available to her. She could have subpoenaed in the keeper of the records.
At the end of the day, do you think that those 4 records, coupled with the judge's findings on that issue, would have tipped the scale the other way?
Well, if we're looking at current fitness, we're looking at adoption of Carlos, we had to look that at this time period, mother had been doing extremely well for those past 8 months. And I think
True,
those
but that's a short window compared to the case.
Yes, Your Honor. But it did show something. It did show that she was making improvements along with...
She should be credited for that, no question.
Yes.
She certainly had.
And where the judge focused so clearly on saying this is a substance use case, those records would have been very helpful, because the judge also makes, when she makes that decision that they're highly relevant, she also said that this will be very important in my analysis of the case. And therefore, if I could state too, in adoption of Mary, the SJC stated that procedural due process is the right to a meaningful opportunity to rebut the state's evidence. Due process concerns and fundamental fairness require the parent have an opportunity to effectively rebut all the evidence, especially, as the judge stated, as she clearly stated, where the stakes are so high in this case, it's termination of parental rights. And
How was Mom doing with respect to visits?
And mother was having visits, to my knowledge, every 2 weeks for, I believe, 2 hours. I think that was the consistent period, so she was consistent with her visits. And that was very favorable testimony. She came prepared for visits. Is my understanding, she interacted with the child.
When the judge denied the request for an additional continuance, she took note of mother's testimony, which outlines her efforts that she made in treatment, which was 7 months clean at the time of her testimony, right? And then there's, as we discussed, some findings in the ultimate decision. So again, getting back to even assuming that there was some kind of procedural problem here, was there really prejudice to the mother on this issue?
You're right, I believe there was prejudice to mother. When a parent shows that consistency, is attending trial all 3 times for trial, she was very consistent during those 8 months, all kinds of programs she's attending, I think she was prejudiced. Because those records, as the judge clearly stated, could have been important in her analysis of fitness at the time. And again, we're looking at current fitness. And Your Honor, the evidence, just in closing, the evidence concedes that without these records, mother could be unfit at trial. However, with these records, there's a real question of whether mother could be determined fit. The trial court abused its discretion and violated due process by denying mother, by not signing that court order and using the vast other resources that the trial court had at their access, such as subpoenaing and doing another subpoena, or summonsing in the keeper of the records for testimony. The other parties would have been prejudiced. They would have been able to ask any questions that they could ask. Therefore,
Of course, while this played a big part in the decision, there were other components to it as well, right? Mental health and domestic violence and complying with the action plan and those other tasks that mom was held to.
yes. And yes, Your Honor, those are very important. But again, we believe it all stems from the substance use. Mother was clear on the stand. She was honest that during that time she was drinking, she was making not the best decisions, and now in the last 8 months she was making decisions. And then those other issues did not occur. Therefore, we ask that this matter be remanded for further evidentiary hearings as to records, or in the alternative, vacate the termination of parental rights and remand for overall further proceedings on the matter. And if I could just add one more thing, I don't know if my counsel will bring up that there were continuances. Very clearly, I believe it's on page 404 of the record appendix. The judge, she did a very nice job of outlining all the continuances. I think there were 12, and only 3 were the fault of mother.
How old is child today? 3?
Child, I believe, is close to 3 years old. Thank you, Your Honors.
Thank you very much. May it please the court, my name is Carol Frizzoli and I represent the Department of Children and Families. Mother was no more fit to care for this child than when the child had been removed at birth after mother used cocaine and fentanyl throughout her pregnancy, did not receive any prenatal care, resulting in her child being a substance-exposed newborn. Mother also admitted that father physically and verbally abused her during her pregnancy. Even after the removal of this child and her 2 other children, mother continued to engage with partners who engaged in domestic violence, continued to use fentanyl and cocaine, continued to engage in criminal activity, failed to address her mental health, and failed to address any of these parental shortcomings with services. Can I interrupt you for a moment? Did I hear you say in the beginning of your argument that mother was no fit at the time of trial than she was before, when the incidents that you're describing now are happening? Did I hear you say that correctly? No, I said mother was no more fit to care for this child. To care, okay. Then because you do agree that there was gains. Absolutely. Gains. And getting into the issues here, the one issue in this case, the judge acknowledged, that mother had made some gains. Now, again, this was based on a January, so trials in August. In January, she was sectioned by probation, and that's when she was put in detox. And she completed the detox. She actually was placed in a sober home in May, and then left
the sober home and moved in with her mother, who had mother admitted on the stand had been a trigger for her for past relapses. Mother had, over the course of this case, and this is the second care and protection case because one involved her older children. I would agree with counsel that substance abuse is a major issue, but it isn't the only issue in this case. And I think the trial judge really detailed in his findings and his conclusions of law, in her conclusions of law, all the different reasons that she found that this mother was unfit. And when we get to the substance abuse issue, mother testified at trial. The judge was able to evaluate that testimony. And what the trial judge was very concerned is mother's failure, the central concern of the court was that she didn't understand the impact of the substance use on her children. I mean, in the case of prenatal-wise, while she was pregnant, she used both fentanyl and cocaine, resulting in her child being substance exposed at birth. She had never had custody of this child. Again, the progress that mother made and the trial court acknowledged it in the findings and conclusions. She was attending AA. But all we have here now is a procedural of 4, and let's look at what these records were. This is literally methadone records where they do random drug screens, and at the close of trial, these were not certified. There were many opportunities. There were pre-trials. There were, as she said, many continuances in the case. There was ample opportunity to provide these. And what it is 4 drug screens from May 2024 to July 2024 that show that she's negative for opiates. In fact, one of them even said she tested positive for marijuana. But that's all this is. These are methadone treatment records. This doesn't show that she was sober for 7 months. But what the trial court did credit was mother's treatment during this time period, that she was engaged in treatment. But even with that, given all the other issues, the domestic violence, her continuance of engaging in these relationships that resulted in domestic violence. Even right before, one of the issues with respect to domestic violence was her testimony against a man who had dragged her into a car and strangled her. She was at the sober house, and she said she didn't go to testify against him. Now, this is in April 2024, which the trial judge noted in his findings. She didn't go to testify because she said she wouldn't have been able to keep her room in the sober house. But again, she left the sober house because she got in an altercation with the staff member. So this is right before trial in June. She had left in May of 2024. So it isn't that these drug tests would have, I think Your Honor's pointed out, it wouldn't have made a difference. And the trial judge had.
These cases are so fraught and difficult for everybody, and it's just, I don't know if disheartening is the right word, but it's odd to see a procedural dispute about evidence that the judge herself has said is highly relevant. And DCF opposed the initial continuance or the second continuance that was granted, and the judge overrode that. Is there something that the department itself could have done to sort of get these records in? I mean, surely you don't disagree that they were relevant to the case. Why not just get the evidence in and then allow the judge to make her decision based on a full record? Why fight this? Why did the department sort of oppose the second continuance request? I just don't kind of understand what's at stake here. What are the countervailing interests that I'm missing? Why not just do everything you can to get this evidence in and then allow the judge to make a decision based on a completely full record?
Because we already had the proffer of what these drug records were, was just 4 drug screens that was done at the methadone clinic. To get them certified, which is what I think the end goal was, to have them come in under 79G, was that it still delayed. I mean, they gave the continuance. They gave 2.
Stipulate to them. I guess is the question. Why not just stipulate to them? Why push back?
Because we didn't know, I mean, there was literally a copy of a sheet of paper. So they're not, how do we, the department still needs to know that they're legitimate drug records. I mean, given these cases, it's very often that sometimes parents, submit documents that might not be, authentic, is all I'm going to say. So again, we need to know that these are legitimate records, rather than saying stipulating. We can't stipulate to something we can't authenticate. And that's exactly what the case was in this. And again, it didn't make a difference because the trial judge themselves found that the mother agreed, said, hey, in denying the last continuance, the trial judge said, but I will note, that mother has been engaged in treatment for the last 7 months. She has, participated, and
I'll take that as your summary of your argument because your time is up. But before you leave the podium, I'll just see if there's any more questions. Thank you very much.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, I'm Creely Pangaro, and I'm appearing today for the child. The child was 2 years old at the time of trial and is now 3 years old. She's lived in her pre-adoptive home since she was 3 months old and has never been in mother's unsupervised care. The child is an appellee in this matter and asks that this honorable court affirm the decrees and judgments of the juvenile court. I'd like to address the denial of a third continuance and why mother's unfitness was not temporary. But first, I hate to quibble, but I think it's important to stick to the record. And the record does not show 8 months of sobriety or of engagement in treatment. The largest amount of time granted by the judge was 7 months based on mother's testimony.
Mm-hmm. Okay.
Mother was involuntarily committed on the 24th of January. That's less than 7 months before trial. So I would like to...
Would you say they were the most consistent 7 months that mom had done well?
Consistent 7 months of mother's engagement?
Yes.
Well, much
And
of...
negative drug screens.
I'm sorry, with negative drug screens? Well, we don't know. I mean, we don't know because mother did not sign releases to allow DCF access to her drug screens.
So you wouldn't say that those last 7 months were the best that mom had done?
The judge, well, I can say that the judge said even giving, even if what mother testifies is true, 7 months, which I consider which is giving mother the benefit of the doubt, that is only 7 months, and there is still clear and compelling evidence of her unfitness. So I just wanted to clear up the 7 months versus 8 months, and note that there was not fentanyl at the time of pregnancy. It was cocaine and cannabinoids that were found in mother and the child.
Mm-hmm.
So that said, I'll turn to the third continuance and why it was proper for the judge to deny a third continuance. There's no merit in the mother's claim that the trial judge erred in denying a third continuance. The trial judge first was acting squarely within her own discretion when she denied the continuance, according to Care and Protection of Quinn, which tells us that decision to continue is within the discretion of the trial judge. Mother, as we've discussed, had multiple opportunities to obtain these records. She knew what evidence DCF would be putting on. She knew that she was receiving screens at her clinic. The trial judge held multiple conferences, pretrial conferences, and mother was the party in the best position to obtain these records. These were her records, and with a HIPAA form, they could easily have been procured.
Was it easy? It seems like the record's a little muddled into what actually happened between the second and third continuance. There was some need to get a court order, then there was some need to get a release from the mother, and I don't quite understand the sequence of events there. If your argument or the DCF's argument is that the mother wasn't diligent, can you just explain to me exactly what happened between the second and third requests for a continuance that the mother should have done a better job, mother's counsel should have done a better job, because it's just not clear to me.
Yes, Your Honor. There is much that is unclear in what happened between the continuances. What is clear is that the judge gave 2 continuances specifically so that mother could obtain these records, that mother was the proponent of obtaining these records, and yet none were produced in admissible form. The trial, in fact, after the first continuance on the 20th of August, the trial judge said, as she granted 15 days, I want to make it clear if those records aren't produced in certified form in 2 weeks, the evidence is closed and there will be no further continuances. So she put the parameters very clearly in place. That's at RA 377. And then 15 days later, mother's trial counsel came back and told the court he had only obtained mother's HIPAA release, which is blank in the record, that day, and the trial counsel conceded that I understand that time has expired, and so it sounds like he has conceded the issue and it's not preserved for appeal. But most importantly, mother cannot show that she was harmed by the lack of these records in evidence, because the mother bases her claim of error on what her trial counsel called consistent with the items marked for identification. We can see those items. There are a provider's letter and 4 screens, one of which is positive for substances. These are not compelling evidence of mother's sobriety, and they are cumulative of evidence that came in through admissible sources, including mother's testimony and the court investigator's report that mother had been receiving screens at Taunton CTC, and the court investigator reported 1 screen in May that was negative and 1 in June that was positive. So we've seen this evidence before, and the records would not have changed the outcome where, even giving mother the benefit of the doubt of her attested 6 to 7 months sobriety, the trial court found mother unfit through clear and convincing evidence. And I would like now to really talk about that unfitness and why it was not temporary. Mother is arguing that the trial judge gave inadequate weight to her evidence of recent improvement. But a trial judge's weight of evidence and credibility determinations are entitled to deference. And I quote the adoption of Flavia, disagreement with the weight of evidence is not an abuse of discretion, which is the standard we are working with here. Let's see, I will go to the judge determined in her sound discretion that mother's pattern of domestic violence, both as a victim of abusers and as a perpetrator of violence against those around her, formed an independent and sufficient basis for a finding of unfitness. That is conclusion number 3 at RA 151, and mother does not challenge that on appeal here. So I would like to also bring the position of the child to this court's attention. The child has been in care all of her life. She's 3 years old and has been living in a kinship pre-adoptive home since she was 3 months old. The child has a right to grow up in a safe and stable home with a caretaker who is responsible and dedicated to her well-being. She should be free from chaos and the threat of violence and instability. And there is no reason to delay permanence. Therefore, the child asks this court to affirm the decrees and judgments of the juvenile court. And thank you for your attention.
Okay. Any questions?
Can I ask a quick question?
Yes, one more question.
You've moved to strike materials from the brief. This is just the mother's inclusion of the methadone records in the record appendix, and you believe that should be struck. Is that correct?
Yes.
You're talking about what the records show and what they don't show. Isn't that something that we can just reference, and at least we understand it's not part of the record that the judge
Right.
made, but we can consider it in terms of assessing this argument of prejudice on appeal, can't we?
Well, I want to clarify, for Your Honor, that the mother, as part of her 60B, or part of her motion for leave to file a 60B motion, mother included 2 materials that were created 6 months after the close of evidence, and those are drug screens and appear to be a provider's letter. Those, for the purpose of the 60B motion, those may clearly be considered. But for the purpose of review of the trial court record, those are inappropriate and should not be considered here. And I just want to note that Mother improperly cites to them in her brief as she characterizes them as records that were offered into evidence at trial at Mother's brief, page 4. That is incorrect. These were created 6 months after trial. Is that clear?
Thank you.
Thank you. All right, thank you all very much for your arguments. I'll echo what Justice Toone said earlier. These cases are always very difficult. There's lots at stake. We understand that. We will give every aspect of this case the most careful attention and render a decision as soon as we can. So thank you all very much. Okay, just stay on the bench.
Sure.
All right, we have our last case coming up next, and I understand that you have a chalk that you want to set up for us. It's our last case, and we're not going to take any recesses, so we're just going to let you come up and set this up while we wait right here for you, okay? So the case is 40 MEADOWBROOK Lane Realty, LLC versus Kyle Andress and another, 2024-1426. And let me ask while this is happening. I understand this chalk has been previewed by both counsel, and it's here for as a result of an agreement by the two of you?
Yes, it was a joint
Okay.
motion, Your Honor. Your Honor,
Perfect.
may I just take a look at it? I have opera
Sure.
glasses.
What?
I'm gonna need some opera glasses.
I think we'll put it right up here.
These same chalks are in our papers?
I'm sorry?
These same chalks are in our papers, is that correct?
Yes.
Okay, good.
Exhibit
So when
one.
you refer to them, please tell us where they are in the appendix.
Because I can see them closer up. It's difficult for me to see. That's pretty small print.
It's even smaller in the record appendix, that's why we tried to
Oh, is
blow
it?
this up.
But we can hold
Fair
the
enough.
appendix close to her. Yeah.
All right. We'll get there, we're sure. Okay. Counselor, go ahead, please.
May it please the court, Attorney Kevin Considine, I represent the appellants Kyle Andress and Gary Andress in this appeal. And, Your Honor, these blow-ups here are copies of Exhibits 1, 158, and 161 in the record appendix. And the reason we...
One more time, 158 and
161.
Thank you.
Do you have a page number in the appendix where we can look?
I could get it.
Oh, well.
That's okay.
I don't take.
That's all right. Unless your time is going, so you should get to your argument.
So, Your Honor, this case, and I'm sure the court's very familiar with the briefs that have been filed, involves large adjoining parcels of property. For 4 years, the parties litigated the issue of the boundary lines between the property owners. We showed up at trial, and the plaintiff, 40 Meadowbrook Lane Realty, abandoned the claim, and I'll explain in a moment why, as to the property line dispute, and tried a case about prescriptive easements. Prior to trial, there was no mention of prescriptive easements in the pleadings, in the pretrial conference report.
Well, there was a mention of it in the pretrial conference report.
I'm glad you mentioned that, and the reference was that the plaintiff may file a motion to add a claim for prescriptive easements. That was in December, 8 months before the trial. We also said in the pretrial motion, pretrial memo, if you do that, we're going to oppose it. They never filed. So we went forward with the understanding that they were not pursuing any claim for prescriptive easement because they never filed. They didn't mention where the easement was going to be.
But you were trying to get quiet title, right?
I'm sorry?
Were you trying to get quiet title on portions of the property?
Yes, quiet title.
Portions.
quiet title, not as it related to a claim for an easement.
Which portions?
This is Exhibit 1.
Okay.
And you'll see this red line here is the plaintiff's chain of title. The blue line here,
That's 40 Meadowbrook.
40 Meadowbrook, yes.
Uh.
The blue line here is defendant's chain of title.
Uh-huh.
And what I'll point out is the defendant's chain of title had this legal description consistent for 100 years. No dispute. Even plaintiff's expert acknowledged that the record title for the defendant's land is consistent with this.
Okay.
What the plaintiff's expert also said is there was no support whatsoever in the record title for plaintiff's deed description represented by this red line. So in answer to your question, Your Honor, we went forward trying to determine which of these lines was the proper boundary line. That was the quiet title issue. The quiet title issue.
Are you talking about the northern boundary line? Excuse, I'm sorry.
Is that the south boundary? Which?
No, this is the north. This is north-south.
Okay, north-south,
I'm
yeah.
sorry. North is up here. South. This is the north-south boundary between the respective properties.
Just to be clear, that's what they refer to often as a northerly boundary. Is that what we're talking about?
The northerly
and both of
boundary.
your briefs refer to the northerly boundary.
Right.
That's what we're talking about.
Correct.
Okay.
And as I said, plaintiff's deed says it's up here. Their own expert said there's no support whatsoever in the record for that, and I'll get to that in a minute. The defendant is here, and even Attorney Troy, the land court examiner, expert witness for the plaintiff, admitted that's consistent in the record title. So what the quiet title issue was to make sure that their claim as to the property line was resolved. It had nothing to do with an easement.
Well, you were trying to get quiet title, which meant they would have had no rights whatsoever to that property, right?
At that point in time, nobody was claiming they had a right to an easement there. That didn't come up until the time of trial. That's the whole point here.
Well, but the evidence was, and the claim was, that they had been using portions of your client's property for decades, correct?
At trial,
Well, that was in the complaint, the original complaint. That was the issue.
no, that wasn't the issue in the original complaint. The issue in the original complaint is who owned this portion of Pine Needle Lane. This is Pine Needle Lane going down here. And in the initial, in the verified complaint, the only count that remained was as it relates to this parcel right here. It's known as 46A or Lot 83. And whether the defendants in accessing their property, which is up here, could interfere with the use of horses on this section right here.
Is that
was
the
the
horse
only
farm?
count.
Is that the horse farm loop trail? Is that what you're pointing to?
If I could just go to Exhibit 161.
I thought the initial claim was that you were interfering with their use of the horse farm loop trail. In fact, had gone from a 30-minute ride to a 15-minute ride based on some obstructions that you put in place.
That wasn't in the verified complaint. What was in the verified complaint is we were interfering right here, this 46A, also known as Lot 83.
Is that the trail?
No. No, this is this is Pine Needle
The
Lane.
complaint specifically refers to these two trails.
It does not. The verified complaint was focused on Lot 46A, right here, and whether we were interfering with their ability to have horses go on that. We had never heard of the horse farm loop at the time the complaint was filed. And if I may just go to this Exhibit 161. This didn't come about until literally during trial, and this is what the court ended up doing is granting a prescriptive easement on the three places where this green line goes over, again, the ANDRESS consistent northern boundary line in this place, and this place. And then added...
Are those places have names?
This is known as the Horse Farm Loop Trail. This orange here is the so-called Crane Street Trail. So what the court did was awarded prescriptive easements for Crane Street Trail and those places on the Andress property where the Horse Farm Loop Trail goes over. That
Was the access points?
Yes, that absolutely was not part of the verified complaint.
Okay, but it seems like that the other side's position is you put everything on the table with your DJ claims, asking for, saying Meadowbrook has no right, title, or interest to that portion of the land. Now, just assume for the moment that that's enough to sort of put into play an easement right on that portion of land. Is there an argument that your claims in the counterclaim didn't cover what the judge ultimately found a prescriptive easement on? Or is it that you don't contend, you contend that your assertion of no right, title, or interest in that portion of land doesn't open the door to a prescriptive easement claim?
The latter. It absolutely doesn't concern this prescriptive easement. We had never heard of a claim of a prescriptive easement at that point in time.
But if we interpret your counterclaim as sort of essentially a declaratory judgment claim to quiet title on the land, it seems like the other side can say, well, at the very least, we have a prescriptive easement. Is that wrong?
But they didn't, Your Honor. What they were claiming is they owned the land up to here, which means the trail would have been on their property. So there was no reason for them to claim a prescriptive easement. They were claiming their property line was up here. The trail was down here.
And when you say they claim, you're referring back to the verified complaint, right?
There was nothing about the north-south.
I know. I guess the question is,
complaint.
did you open the door to this prescriptive easement issue by making a broad assertion of your property rights in the counterclaims?
I would concede that we would do that if there had been any mention whatsoever about a prescriptive easement there. But the only mention at the time of filing the counterclaim was the property line was up here, the trail's down here, so it would have been on their property. There'd be no reason for prescriptive easement. We didn't learn of their claim for a prescriptive easement until we showed up at trial. Yeah. We spent 4 years litigating whether this is the correct boundary or this is the correct boundary.
In your declaratory judgment count, did you ask for quiet title to just that portion, the top portion, or did you ask for the whole property?
I believe it was north-south border. I didn't actually file the...
Wait, I'm not sure I understood the answer to that question.
I believe it was just the north-south border. Quiet title to this, because they were claiming the borders...
Where's that in the record?
I'm sorry?
Where's that? Where can I find that?
It's in our counterclaim, amended counterclaim.
Point to it. What page? Where in the record? Please.
Page 40 of volume 1.
Okay.
And exhibit, answer to your question, Your Honor, Exhibit 148 is at page 163, and Exhibit 161 is at page 166 of volume 4 of the record appendix. So it's really fundamental to understand, had we known that there was a claim out there for a prescriptive easement, then I agree with you, Your Honor. We would have opened the door. There's nothing in the record to show that we were aware of it. They abandoned their claim as to the border, and the court grants their claim for a prescriptive easement. We were absolutely ambushed at trial. Now, whether it was calculated or not, I can't say, but we had no opportunity to conduct any discovery on the location of those trails.
Well, was there a need for that? You took a view? I mean, you knew where the trails were, correct? That wasn't, I mean, in other words, the claim of a prescriptive easement did not just come out of whole cloth. I mean, it was the trails were there, you could see them, the judge went and saw them, correct?
Correct. We did a view. The judge saw the farmhorse loop trail. That was there. We knew it was there. But again, showing up at trial, they claimed it was on their property. This trail doesn't even exist. So we didn't do a view of this trail, but that's a different story. The fact of the matter is we had no opportunity to just conduct any discovery to determine...
What kind of discovery would you have done if you already know exactly where the trail is?
Well, it's a good question. So they show up at trial, and they put three witnesses. The plaintiff, Melissa Doucette, she testifies as to the use of this trail by previous owners of the farm where she was. They brought in a neighbor. He testified as to prior use. We didn't even ask any questions at trial because we didn't know what to ask. We didn't realize that they were claiming that the prescriptive easement, that the trail had been used for years. I think had we known about it, we would have done discovery. We would have found out what the story was with this revocation of license that was recorded by the prior owner.
Given the use of those trails by the public and by the predecessor owner of 40 Meadowbrook, what I'm having hard times understanding is this ambush and surprise. In fact, the judge finds that your client knew about these trails and the use of these trails before purchasing the property. So that's where I'm having a little bit of trouble. I mean, technically, I did just review the complaint again, and I'll look at it, of course, far more carefully, whether or not what exactly is alleged there. But where does this huge surprise come from with respect to the plaintiff's claim?
The huge surprise comes from the fact that we show up at trial on day one, unprepared to defend against any claim for prescriptive easement because we had never been told about one. We weren't told about one in the pleadings, it wasn't in the pretrial conference report, other than they said they may amend. And by the way, when they said they may amend, they didn't say where the trail was. Yes, there was some evidence that this one's visible on the ground, so we knew about it. The owner knew about it. This one just doesn't.
Well, knew about it and also tried to obstruct it. So, of course, you knew about it.
Yeah, and tried to obstruct it because he knew it was on his property. Again, it was a property line dispute. It wasn't a dispute over whether there was a prescriptive easement. That's the whole point here. I see I'm running out of time. I quickly would like to drop down to Chapter 187, Section 5, because I think the court committed an error of law saying that the Andresses have no right to put utilities or make any improvements on this portion of the Pine Needle Lane.
All right, well, I see your time is up, but I just do have a question for you with respect to the statute. So the statute does provide 3 exceptions to what the statute gives the right for the existing owners under certain circumstances to install or construct along the private way transmission for gas, electricity, telephone, water, etc. But there's 3 exceptions. And the second exception is provided that such use of the private way or other private ways does not interfere with or be inconsistent with the existing use by others of such way or other private ways. If we were to find that the judge was correct in determining that the construction of the addition of conduits, manholes, and other appurtenances necessary for the transmission of the gas electricity is inconsistent with a horse path, then does the statute still apply?
It's a 30-foot right-of-way. So
my question is, would the statute still apply if we were to find that the judge was correct in determining that that particular area is to do what you wanted to do is inconsistent with the use of it as a trail for horses?
I think the statute would take precedent, and actually that leads to another one of my issues.
Well, I'm afraid your time is up, but everything is in your brief, and nothing's going to be waived. But let me just see if anyone on the bench has any further questions. No. All right. Thank you very much.
Okay, thank you.
Counselor, I don't know if you're going to be using these chalks or not, but we do have the exhibits and if you know the page numbers of the record appendix where they exist, you can refer to those as well.
Thank you, Your Honor.
Okay.
Yes, may it please the court. My name is John Willis, and I represent the plaintiff, 40 Meadowbrook Lane Realty, LLC. And I'd like to start by responding to some of the points raised by my brother. We didn't abandon the claim as to the boundary dispute. That was a central claim in the case. We had our title expert and our surveyor testify at trial. They did not have any experts at trial. And in the pretrial memo, it referred to the prescriptive easement both in the law section, the facts section, and I think the motion to amend was in a footnote. And we also,
You said you were going to amend your complaint to
Yes, Your
raise
Honor.
this claim, and you didn't. So why didn't you?
Well, we looked at it and we saw it's not an affirmative defense, so we didn't need to amend it.
Not an affirmative defense under Rule 8. So, but you didn't state in the pretrial memo, oh, this is a fair response to the counterclaims, right? You didn't make that argument that you're making now. You just said, yeah, we're going to raise this claim, and we didn't. And you didn't.
Correct, Honor, you did. I was brand new to the case at that point. I just joined for the
that's-
mediation.
Secondary. I'm sure you can answer Justice Toone's question.
Yeah, I mean, there's an issue of fairness here. If you say, well, we're going to amend and add this claim, and you don't really do it, and they get to trial, and now the case is all about the prescriptive easement, there at least facially is some issue about where they actually put on notice that this is going to be an issue at the trial, and if so, did they have an opportunity to obtain necessary discovery and make their own case in response to yours? That's the question.
Yes, I understand, Your Honor, and that's counterbalanced, I think, and that's a fair point. It's counterbalanced, I think, by the fact that they made the quiet title claim as to the northern disputed area, and I'd like to show that on the chalk.
Yep.
Okay, so as to the northern disputed area here, they made that claim in the amended counterclaim, which was filed in 2022, thereby bringing prescriptive easement and all of the rights that 40 Meadowbrook had into issue. And the discovery period ended in 2020. They didn't seek to extend it.
Did the finding of a prescriptive easement, was it limited to that northern boundary? Or was there a prescriptive easement found outside that area?
So, Your Honor, the prescriptive easement as to the Horse Farm Loop Trail is within the northern disputed area. And
Entirely within?
Entirely.
There's no prescriptive easement that extends outside that area?
As to the Horse Farm Loop Trail, correct, Your Honor. And that's the 3 points where it extends into the disputed area. And obviously the prescriptive easement is not as to the parts that are on 40 Meadowbrook's undisputed property. As to the...
And there's, just to be clear, there's no other, the prescriptive easement that the judge found is limited entirely to the area that the other side put into contention with its quiet title declaratory judgment claim.
Your Honor, the Crane Street Trail is not in this.
It's outside that area?
It's outside,
Okay,
yes,
so what's your argument with respect to why was that issue fairly presented? If your primary argument is, well, it got put on the table with the declaratory judgment claim as to the contested boundary line, how do you defend the ruling as to a prescriptive easement outside that area?
Your Honor, my argument would be that ANDRESS has put into issue the northern boundary line, and so it raised the question, how far does it go? And it's not in this hatched area between the boundary line set forth in the deed, but it put at issue quieting title as to the northern boundary line. That would be my position as a Crane Street Trail.
I'm not sure you're answering the question, though. If there's a prescriptive easement that was found outside that area,
yes,
what is the basis to say that you were, that issue was fairly raised before trial?
Your Honor,
It's okay to say it wasn't if it wasn't.
Well, Your Honor, to the extent that it was quiet title as to the properties, it was raised, but it wasn't in that northern dispute
It's
area.
very specific, so just, answer it directly.
Yes, Your Honor. It's outside of the northern disputed area. I think that's correct. So, Your Honor, the amended counterclaim wasn't, Your Honors, the amended counterclaim was intended to end Meadowbrook's prescriptive easement in the northern disputed area. And Kyle Andress testified at trial that a recorded document, which Trial Exhibit 120, ended 40 Meadowbrook's right to use the horse trails, and that's at RA 3, pages 38 to 39. So I think part of the plan is clear from the amended complaint, is clear from the trial testimony they had from Kyle Andress, was to eliminate the prescriptive easements, at least in the northern disputed area. So regarding this disputed area, I guess the western disputed area, that's not an appeal. That was an issue at trial. It's been resolved. As to the northern disputed area, the Andresses are arguing, based on a 1920 plan, that it doesn't matter that the old monuments, such as the old white oak, are no longer there. But a 1920 plan fixing new boundaries can't change the boundaries because grantors cannot convey more than they own. And that's from Bongards v. Millen, 440 Mass 10, 2003. And it's very unclear just what the northern boundary is. So the judge was correct in making that decision that she could not determine, the experts could not determine what it is.
Does that have any bearing, however, on the use of what is Pine Needle Lane, which is where another portion of the controversy lies?
Your Honor, it doesn't have, Pine Needle Lane is this western dispute area.
Correct.
And
so the northern boundary dispute will not have any bearing on that. Is that correct?
That's correct.
Okay.
Just had bearing on the correctness of the judge's decision that the Andresses did not fulfill their burden of proof to quiet title. Pine Needle Lane, it was disputed at trial, and based on our expert's testimony, the judge correctly held that our property went up to Pine Needle Lane.
But there is a question as to the use of Pine Needle Lane, isn't that right?
As to the use of Pine?
Correct.
I'm not sure I understand the question, Your Honor.
Well, isn't that part of the controversy as to whether or not that Pine Needle Lane can be paved and can be used by the defendants? The judge addressed that issue?
Yes, the judge did address that issue. And there was testimony by Kyle Andress on that point, too. He said that it'd be safe for horses to go on it. And so Melissa Doucette was a rebuttal witness to respond to that point. And that was not expert testimony. That was properly admitted opinion testimony and was not objected to. So that properly came in. And that is a reason for an exception to Chapter 187, Section 5, that under the terms of the stipulation, the the improvements to Pine Needle Lane suggested by the Andresses would interfere with 40 Meadowbrook's use of Pine Needle Lane. So her decision was correct on that point as well. And I'd like to point out, 6 weeks ago, the appeals court three-judge panel affirmed the denial of the motion to stay that was filed by the Andresses, and I could...
No, we have that.
Okay, thank you, Honor. I think, okay, I won't repeat anything from that, thank you.
I will say generally you might have filed a letter telling us that and including a copy of it with your letter, but we've located it, so it's okay.
Okay. And also it was in the amended counterclaim in paragraph 43 at RA, volume 1, page 46. That was targeting the 40 Meadowbrook's right to use the horse trails by alleging that it was with permission. So that was part of the plan to eliminate the prescriptive easements. Mm-hmm. And I think it's not accurate to say that the Andresses were surprised by that at trial. I also want to point out that the deed from the Bucklands Trial Exhibit 121 added more land than was in the previous chain of title. It wrote in that deed that there are 50 acres, and that was also in the drawing attached to the deed, and all the prior deeds limited to 45 acres. So that was an attempted land grab. Okay. And as our expert testified, that was raised a lot of red flags.
So you've probably answered this question, and I apologize for raising it again, but just so I'm clear, the prescriptive easement portion that's outside of the northern boundary, how is that in play?
Okay. So, Your Honor, that would only be in play really if it were raised in the counterclaim, if that extended beyond, if the disputed area extended beyond this, this hatched area shown on Trial Exhibit 158.
So what does that mean? I don't know what that means.
Does that mean it's not in play in terms of this appeal?
But I mean, certainly an issue that's been raised by the appellant on this appeal, and that
But what is your view, so that you can answer Justice Desmond's questions? What is your view with respect to that?
As directly as possible, please.
Okay. I'm sorry. Could you just ask the question again?
My question is, with respect to the prescriptive easement that your brother takes issue with because he feels like it's trial by ambush or surprise, how is the portion beyond the northern boundary involved in this legal dispute?
Okay, so as to the Horse Farm Loop Trail, it's within the northern boundary, so that.
Oh, okay.
But as to the Crane Street Trail, it's only involved to the extent that it was a quiet title action as to the properties.
And I thought I heard counsel say that he was only seeking to quiet title with respect to the northern boundary. Is that not accurate?
Well, so, Your Honor, it also was the western boundary. He was originally seeking
to quiet title as to the western boundary. That was an issue at trial, but he just didn't have any experts on it. So we won on that issue. As to the northern boundary, he was seeking to quiet title to it, and the Crane Street Trail is north of 40 Meadowbrook's property.
Okay.
All right, well, I see your time is up. I'm going to see if there's any follow-up questions on that point from you. No, okay. No, thank you.
Thank you.
All right, the court will stand in recess. We have copies of all of those chalks in our appendix, and actually have the ability to enlarge it right on our iPad. So you can just take those chalks with you. Agreed, panel?
Yes.
We won't need them. You can take them back. Thank you for preparing those for us. And we're all done. The court will stand in recess. Thank you all for being here and assisting us today.